this is unlike Castro, and that we don't have jurisdiction even under the narrow reading, which is the Castro reading by your
That is correct.
by your adversary.
That's correct.
Does that make any sense? There has
Yes.
been no review of the merits of this case
Justice
at all
Sotomayor,
by the Court of Appeals.
Justice Sotomayor, the jurisdictional inquiry does not look to whether there's an error and then decide
Well,
whether
they
you have
used it
jurisdiction.
that way. They refused to apply 2255H
We are going to find
by
out if this
dismissing
is
the
working.
case. They didn't deny the application as not newly discovered evidence or not a new rule of constitutional law. They dismissed the case instead of denying it because they said they lacked
That seems to
jurisdiction.
support my point. Their point was not that it doesn't, we're not going to address whether he's right or wrong, the prisoner's right or wrong. We just lack jurisdiction. The same thing is true here.
Well,
The
if they didn't
jurisdictional
lack
inquiry does not
jurisdiction,
turn-
they got the ground wrong.
Okay, well, it was working. Hold on. I don't know. Hold on one second. Sorry, guys. This is my first attempt at playing with this, and it was working for a second.
Justice Gorsuch?
Just real briefly, Mr. Yang, on the merits, you ask us to read all of B, 3A, B, C, D, and E on jurisdiction as a piece, but on the merits, you ask us to split up B. So you say don't split up 3 on jurisdiction, but split up on the merits B. And you say B3 and 4 apply, but B1 and 2 don't. And one of the arguments, main argument, as I understand it from you, is because the first two mentions Section 2254. But the same question I had to Mr. Adler, why doesn't that cut against your view on the merits, given that this provision, B, is all about all habeas, pre and post conviction, federal and state? You agree that that's the case? And
I'm sorry, do you mean all of B or just B3 and B4?
Well, B, 3 and 4 are all about all applications. Everybody,
Yep.
everybody's in, pre and post. And what the inclusion of 2254 tells us is that that's addressed to post-conviction applications. Why isn't that a natural understanding that it's actually more applicable in the 2255 context? We have to read motions as applications anyway under your reading. Why aren't these the most relevant applications for federal prisoners?
2255 is post-conviction too.
I understand that. That's my point.
I guess I'm confused because
All right.
Congress has chosen.
I'll ask you
Congress
to-
chose distinct language here.
Yes,
I'll
I
have
understand
more
that.
to say in a minute,
I'm
guys.
asking why.
still trying
That's
to
all
make
right.
sure
I'll
I've
ask
got the
Meeks.
tech running.
Thank you, Justice Gorsuch. Justice Barrett? Justice Jackson? Thank you, counsel.
Thank you, Your Honor.
Ms. Mitchell?
Mr. Chief Justice, and may it please the court, on the one-year anniversary of Timothy McVeigh's bombing of a federal building, Congress passed EDPA to advance the finality of criminal convictions. Congress largely did away with post-conviction applications by federal prisoners, requiring them to file motions under Section 2255. And Congress amended Section 2244 to provide finality requirements for state prisoners who largely seek post-conviction relief via an application under Section 2254. Everyone agrees that Section 2244 is principally about state prisoners, and that there's a cross-reference that makes it applicable to federal prisoners. That structure means that there is going to be language in 2244 that is specific to state prisoners. And you have to read that in light of a cross-reference that makes language about state prisoners apply to federal prisoners. Everyone agrees that the cross-reference incorporates 2244 B3C, which says to apply the requirements of this subsection, subsection B. And the very first requirement of subsection B is the do-over bar. That interpretation follows from simple statutory cross-references. It also makes perfect sense in light of Congress's clear goals. There is no reason to think that in the landmark legislation passed in the wake of the Oklahoma City bombing, in which Congress was trying to focus on finality, it entirely eliminated any do-over bar on post-conviction motions by federal prisoners like McVeigh. I welcome the court's questions.
Ms. Mitchell, both the government and petitioner, though, put more weight on the difference in language in 2255 and 44. The language application versus motion, that there's more emphasis on habeas for state prisoners. How do you reconcile that, the difference in language?
Justice Thomas, the way you reconcile this is because you're viewing this statute via the lens of a cross-reference. I think this is really important to understand what both the government and petitioner are arguing. They're saying that when you see the word application, on its face, it includes federal motions. That carries significant consequences for AEDPA. In the statute of limitations provision, for example, 2244 D1B, Congress distinguished in the state context filing an application. In the statute of limitation provision governing federal prisoners, 2255 F2, it used different language. It said an impediment to making a motion. That application and motion distinction was critical to AEDPA. Both the petitioner and the government say, well, we're just going to read application to mean motion, and I don't think you can do that. Application means application. You apply it to motions via cross-reference. And that's why, to Justice Gorsuch's question, the under 2254 language makes it a closer fit to 2255 motions than the general provisions in subsection B3. B3 speaks only of applications, which on its face excludes 2255 motions. In addition to rewriting motion to mean application, both the government and the petitioner want to rewrite the language this subsection. And again, that has sweeping consequences not just for AEDPA, but for the U.S. Code. One of the principal decisions that my brief relies on is the Cyan decision, where this court said clearly that when Congress means subsection, says subsection, it means subsection.
But why wouldn't we take that to be right in the category of the very first thing that you said, which is we all agree that this 2244 primarily applies to state prisoners, and that there will be language as a result that might not be a perfect fit because it's directed to state prisoners.
Thanks,
and I
Ms.
would
Aroni.
think this subsection is that kind of thing.
I don't think so, Your Honor, because this subsection is direct command of the cross-reference, and it says to apply all of B, and that's part of the very provision that everyone agrees is incorporated.
I understand, but your view of this makes us think that Congress was trying to get to B1 in the federal context through two cross-references. That seems like such an odd way. I mean, if Congress wanted the B1 bar to apply in federal habeas scenarios, they easily could have just written that, or in H, they could have directly referenced B1. But you get us there through the cross-reference in H and then the cross-reference in B3, and that just seems so strange.
I think that's the easiest way to do it in light of all of the parties' agreement that B3C applies. But there's another path, which is just to say on its face, it's a requirement that applies via the cross-reference, because the cross-reference says as provided in 2244, and you're going to bring in subsection B1 which isn't displaced by H1 and 2, which applies. I mean, we think
So
that
the
the
rule
better
is
place
that
is
you
to
can
start where all
only
the parties
bring,
agree,
if you are
but I'm not
in
gonna
a
resist a
state
reading that we
jail
bring it in
or state
on
prison,
the as
and you
provided
want to
in
bring
2244
a
cross-reference
habeas
alone.
corpus
Thank you.
claim
In
to the federal
addition,
prison and say, I am
just to
being, or
comment
federal courts
on
and
the
say,
problems
I am
with
being
reading
held
subsection to mean
illegally.
something else.
You can
Not
only bring
only
that
did this
claim
court confront
one
that in the
time,
Cyan decision,
unless
which neither the government nor
the
the
Constitution
petitioner even
changes, the
cite
reading
in
of the
their reply
Constitution
brief.
changes,
But it's been an
or
issue
you find
in
new
numerous other
facts.
cases that this court has confronted, including with respect to the Federal Vacancies Act in NLRB versus Southwest General and throughout.
Argument is
We
whether that
also
applies to
know
federal,
that in EDPA,
prisoners as
Congress
well
knew
or
how to
not.
specify and pick and choose provisions when it wanted. So for example, in 2264B, Congress said, following
I'm
review,
curious.
subject
I'm working
to
on that
subsections A,
right now as we speak. This is my
D,
first time ever
and E
playing with
of
this.
Section 2254. The court
So
shall
I'm
rule on
seeing
the
if I
claims
can
properly before it. So there are other examples in EDPA where
find a
it
way to do
picked
some
and
text.
decided to pick and choose among subsections, and it was specific. Here, Congress enacted a wholesale cross-reference with respect to, at a minimum, the certification provisions that all agree include B, 3, C.
What do you make of the fact that Congress, to your alternative point to Justice Jackson, that Congress didn't just end it, 2255H, after, as provided in Section 2244? They could have just ended it there, and then the cross-reference would have been complete, I think. And what are we to make of that other language, if anything?
They could
This
have done
is
that. There are two
Bowe
reasons why I
v.
think
United
they didn't.
States,
The first is because they were bringing over the
24-5438.
certification procedures. And the second is they wanted to provide constraints on the abuse of the writ, which is what H1 and 2 principally address. So in the pre-EDPA context, there were two problems that the court faced with habeas corpus applications. One was the successive problem. So you have someone who's bringing a claim that they've brought again. A separate and distinct problem was abuse of the writ, which is where you held on to a claim, you brought one, waited, you brought your other one and another one in a second application, you'd bring a third one. That was a distinct problem, abuse of the writ. And in 1948, when Congress amended EDPA, they added in 2255 a successive bar. So what Congress said was the sentencing court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. This was in the 1948 Act. This court interpreted that language in Sanders to say, Section 2244, and this language is addressed only to the problem of successive applications. And what the court did is said, well, we're not going to read that to read out the abuse of the writ doctrine.
Everybody's
This is addressing successive applications, and we're also going to apply
kind
abuse
of
of the writ doctrine.
seems to feel like they
The
agree.
provisions in 1 and 2, which are
that this
now
only
after
applies
the
to states,
2008
so I think
technical
that's how it's
amendments,
gonna end up.
H1
But-
and 2, only address abuse of the writ. So there's no reason to think that when Congress omitted that language and instead put a cross-reference to 2244, that it meant not to include the number one finality promoting provision, which is B1. Additionally, there's some argument that the government and the petitioner make that this is really not a problem, kind of what are we doing here? But Judge Rosenbaum in the 11th Circuit observed that in the 3 months after this court's decision in Welch, the 11th Circuit saw 1,800 applications for Johnson-based review. So I do think it is a real problem that courts are grappling with. And the tools that Congress gave the courts of appeals to deal with this problem allowed it to make the expeditious determination under the 30-day clock. And what petitioner and the government would say is, well, we're going to take one of those key tools out of their tool belt. We're not going to allow them to look and see, was this argument already presented? And if so, can we dismiss it on that basis alone? And that makes it more difficult to accomplish its task in 30 days. I think one thing is significant about that also is Congress provided the same 30-day clock for state prisoners and federal prisoners. They didn't say we're going to give 30 days for state prisoners and 45 for federal, or some other indication that they intended to treat them differently. And Justice Thomas, to your question to the petitioner, all indications by use of legislating by cross-reference is that Congress wanted to treat, at least for successive applications, state prisoners and federal prisoners alike. That's why they chose this kind of clunky mechanism to do so via cross-reference. One additional point, petitioner, in response to one of the questions about jurisdiction, said that there's a clear statement rule as it relates to state prisoners with the jurisdictional point because of the word application in 3E. That's significant because that is saying that is a clear statement that this applies to state prisoners, which is exactly our point. Every time Congress said application, it was excluding on its face federal motions. So in order to read any of these provisions as applying to federal motions under 2255, you have to view them in light of the cross-reference. And that's exactly
Bowe v.
what you
US
do
right
when you look at 3C's cross-reference to
This is
B1.
about,
You read that
habeas
language,
corpus,
a successive
and whether
habeas
it
corpus
can be-
application under
whether
2254
two applications
in
can
light
be
of that
filed by the same
cross-reference
prisoner
to apply to
on
similarly
the same
situated
issue.
federal prisoners. And again, Justice Gorsuch, to your question, it's not like it says applications by Guantanamo detainees. I think my argument would be harder if the additional language was something that didn't map on so tightly to the 2255 mechanism, but instead that's a closer fit than the application language that the government and petitioner rely on to bring in the certification provisions in the first
Which can
place.
include pre-conviction detainees.
Yes, Your Honor.
Yeah.
And so it's just a natural fit to see what Congress was doing there. Again, in the wake of Oklahoma City, there's no reason to think that the #1 finality provision in 2244, which was titled Finality of Determinations, that they intended that not to apply to federal prisoners like McVeigh, which was the exact target of the 1-year anniversary when President Clinton signed this bill into law.
Implicit repeal of a power federal courts had previously to prevent do-over petitions by federal habeas petitioners.
Exactly. And instead, they rooted them through the provisions for 22, provisions that otherwise applied to state prisoners. And one important
This is a
point,
different one,
the
Cadence.
standalone language that prevented successive applications by federal prisoners
This
had long
person
been
filed
marginalized
a
by this
habeas
court.
petition in
In Sanders, the
2016.
court said this
The
can't
law
be taken
changed,
seriously.
and
so it's
he wanted to
perfectly
file
natural
another
for
habeas
Congress to
petition
say,
because
you
the
didn't-
law is
you
more
didn't
on
do
his
what we
side now.
said in 2255, and instead
But the rule
this time
says you
around,
can
we're gonna
only
put you in
apply
the
for
same
habeas once
bucket as state prisoners where
if
you
you're
will
a
enforce
state
the
prisoner,
successive
but
bar.
he's not a
And
state
the
prisoner, he's a
combination of
federal
B1
prisoner.
together with
And
subsection
the
1
question
and 2
is
in
whether this applies to federal
addressed both
prisoners
the
as well, or whether they're
successive
allowed to come
and the abuse
multiple
of the writ
times.
problems that Congress was targeting in EDPA.
Thank you, Justice Thomas. Any further? Justice Alito? Justice Sotomayor?
I believe this is the third person they brought in to
Would
argue this
apply
because
to successive
neither of the
positions
other
in
parties
federal
were
court.
arguing
So
the
you get
point
to the same
harshly
place,
enough. So they
just a
brought
different
somebody in
issue.
special just to
That's
take
quick.
the extreme side
That's
here.
not true, Your Honor. There are decisions by this court saying that res judicata does not apply in the habeas context. And instead, what 2244 and 2255 did was, and this is in the legislative history, was to codify a modified res judicata principle. So res judicata traditionally has not
Thank
applied
you.
in habeas.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett? No. Justice Jackson? Thank you, counsel.
Thank you.
Mr. Adler, rebuttal?
Thank you, Mr. Chief Justice. We acknowledge that this is a technical case, but I'd like to try to simplify how the court should resolve it if it agrees with us on B1,
Gen X,
which we
it's
do
a
believe is
narrow
resolved
case.
on the face of the provision. This is
Prisoners
the
would
rare
get
EDPA
a
case
federal
where the
prisoners
plain
would get a
text of the
second
statute
chance to
resolves
bring
the question. So if you
a
agree with us on
habeas
B1, then on the jurisdictional question, there's two options, I think.
If the law
One
changed in
is
their
the government's
favor.
late-breaking suggestion on page 12 of its reply brief that to dismiss this case for lack of jurisdiction and indirectly resolve the B1 question. This goes to Justice Barrett's suggestion earlier. Our concerns with that remain that there is a significant risk that doing that would not resolve the circuit conflict unless the court is crystal clear that it is purporting to resolve the B1 question in a holding. We also have significant concerns about whether Mr. Bowe, of all people, could benefit from that. We appreciate the government's suggestion that he could refile. However, we are not sure about that in light of some language in the Bradford decision, 11th Circuit, that says the B1 dismissals are with prejudice. And if anybody should benefit from a statement by this court on B1, it's Mr. Bowe, who has been waging a 3-year campaign designed to eliminate this atextual obstacle that has been placed in front of him. So that's one option. We think it is highly unorthodox and can be avoided simply by accepting one of our narrower jurisdictional arguments, and we have given the court 3 of them. We think the clear statement rule applies to all of them.
Yes,
I
this is
don't
live.
understand how the government can say there's no clear statement rule when Castro says it on this particular statutory provision. We don't have to do
Yes,
two
the
steps.
argument
it's
is
right
live,
there on the
Jamie.
face of the opinion. And by the way, the case it cites for that is not Utah versus Walker. It is Felker versus Turpin, which is a habeas case. It says no implied repeals of habeas jurisdiction. The court applies it here to B3E. Justice Jackson, I think you have identified the simplest way to find jurisdiction over this case, and it is the fact that the Court of Appeals dismissed this without ruling on the merits. It did not grant or deny. The text of B3 is very clear that we have grants or denials and we have dismissals. The court here dismissed this case improperly. That's not the error that we're complaining about. That would be harmless because the effect would be a denial. But it is the reason why there's jurisdiction. There's no denial here. That follows directly from this court's B3 precedent in Stewart, which also involved the dismissal, no merits ruling, and the court said the effect, even though it was to grant it, didn't matter. It wasn't a grant. And the final thing about that, if the court simply clarifies that in this opinion, that courts of appeals should not be dismissing claims in this posture, but should instead be granting or denying them, then the court will not see a single cert petition under that theory come to this court, because the courts of appeals will simply grant or deny moving forward. And so if the court is concerned about receiving additional cert petitions under the statute, that's the easy way to go. And so at the end of the day, we think the text of B1 is plain. This court has jurisdiction to effectuate that text and resolve the circuit conflict directly once and for all. Thank you.
Thank you,
So
counsel.
vigilance, the question here is,
Ms. Mitchell,
if somebody brings a
the court
habeas
appointed
thing,
you
they say
to
I'm being
brief and
held,
argue this case as an
I'm being
amicus
imprisoned
curiae.
incorrectly.
In support of the judgment below as to
you
question
can
one,
only
you have
bring it
ably discharged your
once.
responsibility, for which we
This
are
guy
grateful.
brought it in
Case is
2016,
submitted.
and a few years later they changed the law, so he wanted to bring it again and try again. But they said, you're not allowed to do that. You're only allowed to bring it once. He is a federal prisoner. That rule usually only applies to state prisoners because they can bring those same cases in state court as well. So they're allowed to bring it multiple times in state court. They can only bring it to federal court one time. And so the question is, can he bring it multiple times in federal court or not? And so that's what they're deciding today. Whether that rule should be kind of changed to allow for federal prisoners to bring it more than once. And that's very cute. Brandon Sanderson jokes. Yeah. I want to say I don't look like him, but I'm told very clearly that I'm not correct. Vigilance was okay. Hopefully that was good. Thank you. So we're going to have a second here where I don't know how long it's going to be until we move on to the next case.
We'll hear argument next this morning in case 24-482, Ellinburg versus United States.
So Ellinburg
hurry up.
is
Mr.
another
Chief
criminal
Justice,
case.
and may it please the court. The MVRA classifies restitution as criminal punishment
about
and is
ex
thus
post
subject to the
facto
ex
laws.
post facto clause.
You
Just like
cannot make a
imprisonment and
law, a
fines,
criminal law, that
restitution is
applies
part
to
of
a
an
crime
offender's criminal
yesterday.
sentence, imposed at the end of a criminal proceeding as a consequence of conviction. The sentence is the punishment for the crime. Other features of the MVRA confirm this conclusion. Restitution is intertwined with other punishments
Sometimes
and can be the only punishment for
A judge
misdemeanors.
will apply
Like
a
fines,
restitution as part of the
restitution is
punishment. You got to
enforced with
pay
the
your
threat of summary
victim some
imprisonment.
money.
And
And the
federal
question
rules
is
of criminal
that a
procedure
punishment
and the chapters
that's
of
not
Title
allowed to be
18 that
changed
govern
after the
sentencing
crime?
apply. All of this is why, in a trio of cases, Paroline, Pasquantino, and Kelly, this court called restitution a criminal punishment that serves punitive and penological purposes, and a criminal sanction that furthers the government's interest in rehabilitation and punishment.
Guten Morgen.
Amicus responds that victim compensation is the primary purpose of restitution, but that purpose-based analysis overlooks the threshold classification question. Does the statute on its face impose criminal punishment? The answer here is yes. Criminal punishments may serve multiple purposes at the
I gotta
same
change
time.
the text.
Imprisonment
Hold on.
punishes, but also protects the public.
Oopsie,
The
that's
same
not
is
what I
true
wanted to
of
do.
restitution. It punishes the offender, and
Hold
if
on.
the offender pays, compensates the victim. Finally, This case presents the question presented. The MVRA is the law being applied to petitioner retroactively. The district court that denied the show cause motion applied the MVRA, and the Eighth Circuit then affirmed on the ground that the MVRA imposes a civil remedy. The petition challenges that case dispositive holding. I welcome the court's questions.
So, question is,
Aren't we going
basically
to
this
have to
guy
wrestle
was,
with the fact that,
he went through his trial in
petitioner was not originally
1995,
sentenced
and he
under
was
the
told,
MVRA?
you have to go to jail
We
for
don't think
a bunch of
the
years,
court needs to
and you have to
wrestle
pay
with
your
that
victims
fact, and I'll start by saying it's not
$7,600.
clear
But of course, he's in jail. He's not
what,
making any money,
statute
so he
the
pays
original
little
sentencing
tiny
of the
bits.
court
And
applied
the rule
30
at that
years ago.
time
All we have
is
a
you have to
judgment
make these
form.
payments for
The
20
judgment
years,
form
and then
simply
you're done.
imposes an
No matter how
amount
much
of
you've paid
restitution,
off, after 20 years,
and,
we'll let you go. So
the-
he hits
there's
those
one
20 years
portion of
in
the judgment
2016.
form that
The
at-
problem
at-
is that
at
a little bit
27A
after that, they
that
changed
cites
the
to
law
Section
and said that 20 years
3663
doesn't
in
start
one
until you get
paragraph,
released.
but the checks-
And so the
check
question
box
is
in front of that
are
paragraph
they
is not
allowed to
checked.
do that to
So
him?
there's
Is this a
nothing in the
criminal
judgment
punishment that
form
you're
that
not allowed to
indicates
change
that
after
whether
the crime
district
is
court that
completed
sentenced
or not?
Mr. Ellinburg
Ex
applied
post
the
facto laws are not,
VWPA
you're not
or
allowed to
the
change a criminal
MVRA.
law after
Now,
the crime's
under
completed.
the rationale of the decision below of the Eighth Circuit, the MVRA was the statute
Does that make any sense, guys?
governed the restitution order imposed
I know there's two
at
voices going on at the
sentencing.
same time.
Because the Eighth Circuit
I
held
think
at the urging of the
that this
government
will
in this
be,
case,
I'm pretty
that
sure
the
they're going to
MVRA
hold that this
imposes only
is
civil
a
remedy.
punishment. This is a,
As a
it's
result,
too
under the
close
effective
to
date
the
provision of the
punishment. It's not a
MVRA,
civil
it was
penalty.
in
It's
effect
really
at the
close to a
time of the
punishment.
sentencing, and it
It's going to be
applied
really
because
hard
there
to
was no
say this isn't part of the
constitutional
punishment
barrier
and
to
something
its
that can be
application.
changed later.
That is the rationale that the government argued to
There
the
is
Eighth
some
Circuit
logic
below.
to saying,
The Eighth
you know,
Circuit accepted
well, of
that
course he
argument.
can't
The government
pay
continued
it while
to
he's
argue
in
that
jail.
its
It makes
brief in
more sense
opposition
to let
to
him
our
pay it when he
cert
gets
petition at
out,
page 3, where
when
it
he can make
again
more
said
money. Because
that the
$7,600,
MVRA
not that much
was
money,
the
but it's
statute
not
that
always going to
governed
be
this
$7,600,
restitution
right? It's
order.
going to be more than that at some point.
And isn't your key point that regardless of what happened 30 years ago, today, your client is being held to the responsibilities of the MVRA?
Absolutely, Your Honor.
So, you know, you still, I would think, have an ex post facto argument because no
Thank you,
one
Dana.
disputes that the MVRA was not in existence at the time he committed the crime.
Correct. We all agree that the statute that is being applied retroactively is the MVRA. Correct. We couldn't make an argument that the VWPA was applied retroactively. That was in effect at the time of the offense in this case.
And of course you would win if you did, because then he couldn't be held to the very provision that you are trying to get nullified.
That is the argument that we will make on remand if we end up on remand. I think the government takes a different position on that issue. They think that the MVRA liability period provision can apply even if the restitution order was imposed under the VWPA. But that would be an issue for the Eighth Circuit to resolve on remand. Now, on the merits, I will just start by saying that it's crystal clear that restitution is part of the criminal sentence. This court said that in Manrique, and there are a number of textual indications of that fact in the statute, starting with section 3556, which is in the chapter entitled Sentences. That provision instructs courts to impose restitution in imposing a sentence on a defendant. It then points courts to 3663 for discretionary restitution and 3663A for mandatory restitution, both of which instruct courts to impose restitution when sentencing a defendant. In numerous parts of the code, Congress used the language, a sentence of restitution. For instance, in 3611, it said a person who has been sentenced to pay a fine, assessment, or restitution. Sentenced to pay restitution. And it makes sense that Congress made restitution part of the sentence because it viewed restitution as a punishment that had consequences for other criminal punishments.
Section 3664M allows victims to enforce restitution as a judgment lien under state law. Are you aware of any criminal punishments that victims can enforce personally?
No, I think this is probably the only one. The MVRA gives victims a very limited right to enforce restitution by obtaining a lien on property within the state where the conviction was imposed. It does not give victims the full range of civil enforcement mechanisms, such as garnishment, for instance. It does give that full range of enforcement mechanisms to the Attorney General. The Attorney General has the same authority to collect restitution as she does to collect fines. And it's telling that Congress treated restitution just like criminal fines. Both
But doesn't the fact that the victims can enforce the restitution order themselves cut strongly against your argument that restitution is penal rather than looking to provide remedies for the victims?
I don't think so when you look at the entirety of the statutory scheme. Again, first, the fact that it is part of the sentence. Second, that the sentence can be enforced not only through civil liens, but through the defendant's freedom. This court made that point in Pennsylvania Department of Welfare versus Davenport, where it noted that restitution obligations differ from ordinary civil obligations because they are secured by the defendant's freedom. In Section 3614, Congress authorized courts to impose any term of imprisonment that may have originally been imposed as a resentence in cases where defendants fail to pay both restitution and criminal fines.
Is there any reason you can't have a civil proceeding running parallel to the criminal proceeding? You know, the state has an agency to allocate fault in the case of auto accidents, and whoever has to pay, and somebody steals a car and, crashes the car, and he's criminally prosecuted for that, and in the same accident, just has to go through a civil process where he may also be assessed a fine. Is there anything wrong with that?
No, I think Congress could have chosen to do something like that. Now, depending on how it was structured, that may raise some serious problems under the Seventh Amendment. But putting the Seventh Amendment consequences of such a scheme aside, Congress might have created such a system, but that's not what it did here.
Could it just say, we intend this to be civil and have the operations of the statute operate in the same way, and then we would say it's civil? In other words, it seems odd that so much turns on the label as opposed to the operations of how the statute works.
Well, I think if Congress perhaps just said the word civil but did everything exactly the same, we would still be before you arguing that that is quintessential criminal punishment. But this court has said that the inquiry at the first step of the criminal punishment.
Person who's a victim can also bring a civil claim and get paid that way.
Like a tort suit. I know
that would be unrelated to
folks
this.
Have characterized this as just a tort suit-like.
Sure, I think if it's still part of the sentence that is imposed by the sentencing court as part of the sentence, together with imprisonment, fines, probation, all of the other criminal punishments, I think our position would still be that is criminal punishment. But Congress could have written a different statute that would have accomplished something civil, again, wrestling with the Seventh Amendment consequences of that. The Seventh Amendment is, I think, important here because it is part of the backdrop against which Congress legislated in the MVRA. In the wake of the VWPA, which was the predecessor to the MVRA, the courts of appeals uniformly rejected Seventh Amendment challenges to restitution on the ground that restitution is criminal punishment. This court commented on that uniform consensus in Kelly versus Robinson before Congress enacted the MVRA. This court also construed the VWPA in Huey before the MVRA and applied lenity to the VWPA as a criminal statute. All of that is part of the backdrop against which Congress enacted the MVRA. And not only did Congress not do anything to signal it was intending to depart from that consensus, but it carried forward the same operative language from Section 3663 in the VWPA.
And in its legislative history, didn't it seem as though Congress was pretty clear that this was not just about compensating the victims? I mean, I see here a quote that Congress says that the MVRA is, quote, needed to ensure that the loss to crime victims is recognized and that they receive the restitution that they are due. it is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. So it seems as though, at a minimum, Congress was doing more than just saying the victim has to be compensated. And if that's the case, why is it characterized as a criminal statute if there are two motives operating?
Sure. May I answer?
Please.
So to take those questions in two parts. First, absolutely, Congress made crystal clear in the legislative history that it thought the MVRA was a criminal statute. If you read the Senate Judiciary Committee report, it uses the word criminal more than 40 times, and the only time it uses the word civil is to distinguish restitution from civil proceedings. Now, to take the second part of Your Honor's question, the inquiry that this court has adopted for when is something criminal punishment just asks whether Congress intended to create criminal punishment and whether it has some other purpose, such as here compensation, such as in the case of imprisonment, protecting the public, doesn't matter because all punishments serve more than one purpose.
Thank you.
Thank you. Justice Thomas? Anything further? Justice Alito?
What will be left of Smith if we rule in your favor? Suppose that a state sex offender law provided that the sentencing judge would determine how long an offender needed to register, or suppose that the state could summarily revoke probation if a defendant failed to maintain his registration. Would that mean that the sex offender law would be penal?
Not necessarily, Your Honor. We don't think there's any inconsistency between a holding in our favor here and Smith. In Smith, the requirement to register as a sex offender was not imposed as part of the sentence. The legislature used the sentencing process simply to notify the offender of the need to register, but it was not imposed as a punishment. There is a distinction between the sentence itself and conditions of release or probation. Those are conditions on the sentence, but are not the sentence itself. So we don't think that a condition of release, such as the obligation to register as a sex offender, would necessarily amount to criminal punishment in the same way that conditions of imprisonment, like cell phone restrictions, are not themselves punishment.
Would you say that the primary function of restitution under this statute, the statute you would like us to apply, is penal or civil?
We think
the primary function is the primary function to punish, or is the primary function to provide compensation to make victims whole to the extent possible? Which is primary?
The court in Paroline said the primary purpose is compensation, but we think the penal purpose here is just as important and primary, I would say, as the compensatory purpose.
Justice Sotomayor?
Is a restitution payment
the
there
statute,
to compensate, or is
drug
it just
offenses,
there to punish them?
Order restitution to the society, don't they?
Yes, and we think
So that's why you're saying it's equal.
yes, that's a very good indication that Congress was intending to do more than simply compensate individual victims.
Number two, our ex post facto jurisprudence has three components. Was it being applied to previous conduct? The first is the question before us, is it criminal or civil? But that there's a third component, does it increase punishment? On that question, there's a circuit split, and we didn't grant cert on that, correct?
That's correct.
So this, at worst, would be a reverse remand.
Yes, we agree with that, and I think the government does as well.
Okay. Thank you.
Justice Kagan?
What about these provisions that say that, on the one hand, the award is offset by any civil judgment received, and on the other hand, that the victim can keep coming in, however many years later, to offer proof of further damages? That really, both of those seem very odd if the statute is primarily punitive.
Sure. So as to the first one, we think that feature of the scheme supports us as a matter of statutory construction, because those provisions, which are in 3664J and L, distinguish between what happens at at sentencing, at the imposition of restitution, and what happens in a subsequent civil proceeding. And the fact that Congress used the word civil proceeding and those particular provisions, we think makes quite clear that it understood that what is happening at sentencing when restitution is imposed is not a civil proceeding. Now, as to the second point, the fact that victims can come back at future points, first, that is cabined by a good cause requirement. There needs to be some reason why that was not presented to the sentencing court at the time of sentencing. But putting that aside, we think that one particular feature of the statute, similar to the narrow opportunity to obtain a civil lien, just doesn't overcome all of the indications that Congress understood it was imposing a sentence.
Thank you. Justice Gorsuch? Justice Kavanaugh? Justice
Makes
Barrett?
sense, Crispus.
Justice Jackson? Thank you,
Thank you.
counsel. Ms. Robertson?
Mr. Chief Justice, and may it please the court,
This should be
Congress
government.
implemented restitution under the Mandatory Victims Restitution Act as criminal punishment. The text makes plain, first, that restitution is punishment. In the statute's terms, it is a penalty or sanction. And Justice Alito, to your question, that fact alone distinguishes restitution in this case from the registration requirements at issue in Smith versus Doe, which this court held wasn't punishment at all. Then the court has to consider whether this is criminal or civil punishment, and we think the text is equally plain that it is criminal. Restitution is imposed for a criminal offense on a criminal defendant at criminal sentencing where the United States stands as the adversarial party. And if there were any doubt, the statutory history dispels it. The Court of Appeals had uniformly held that restitution under a predecessor statute was criminal punishment, and Congress replicated the relevant language in the MVRA and doubled down on features indicating a punitive intent. This court should vacate so the Court of Appeals can consider in the first instance the United States' alternative arguments for affirmance. I welcome the court's questions.
Does it make a difference if this sanction was imposed in a separate proceeding?
Does it make a difference if it had been imposed outside of the sentencing context? Well, I don't think it would change the nature of restitution as punishment, given that Congress refers to it as a penalty, but it might change whether we conceive of it as a civil penalty, like the administrative penalties at issue in Hudson or in Ward, or whether we consider it a criminal punishment. The fact that this penalty is imposed in a criminal proceeding is one strong indication that it is meant to serve as criminal punishment.
Do you think that all sanctions imposed in criminal proceedings are in fact penal or criminal?
So I think this is an important distinction, Justice Thomas, and I want to be clear that we do distinguish between what is part of a criminal sentence and what occurs at criminal sentencing, because we agree with amicus that not everything that occurs in criminal sentencing or even that appears in a criminal judgment is necessarily part of the punishment and therefore part of the criminal defendant's sentence. So the classic example here would be the registration requirements at issue at Smith versus Doe. Because those requirements were announced at sentencing, they even appeared in a judgment, but that didn't make them part of the sentence because they weren't meant to add to the defendant's punishment at all. So here, it is quite important to our analysis that Congress has specified that restitution itself is meant to serve as a penalty or a sanction. And that is a point that we would hope that the court would be clear on in its analysis, because we do think that there are things that might come up at criminal sentencing, including conditions of supervised release, that we wouldn't conceive of as punishment at all. So we do think that when the court engages in the statutory construction here, it is paramount to us that Congress labeled this as a penalty or a sanction, and that we think that that really washes away many of amicus's arguments about the non-punitive purposes that restitution might serve, because of course we agree that restitution can serve important compensatory goals, but when Congress has told us expressly that it intends restitution to be punitive, it intends it to be a penalty, that answers the question as a matter of statutory construction.
Just to summarize, what should we say, in your view, in the opinion, to prevent spillover effect that you're concerned about? What are the key components?
So we think there would be two important points for the court to make in the opinion. First is to be clear that it is resolving this as a matter of statutory construction under step 1, not under step 2 of the Mendoza-Martinez test, because we do think restitution is the type of penalty that can be implemented as either criminal or civil, and Congress and state legislatures have chosen in some circumstances to implement restitution as a civil penalty. So we think a decision that makes clear that the court is resting on a matter of statutory construction under the MVRA will leave appropriate room for legislatures in future cases to treat restitution as civil. When it comes to statutory interpretation, we think it's important that the court not single out any one particular feature that makes restitution a criminal punishment. Rather, we think it's important both that the text is plain that it is punishment. As I said, it's referred to as a penalty. Elsewhere, it's referred to as a sanction. Elsewhere, the text refers to defendants who are sentenced to restitution or a sentence of restitution. And then when it comes to the question of whether it's a criminal punishment, it's important to us that all the textual clues here point in the same direction. And that includes that restitution is predicated on a criminal conviction, that it's imposed personally against the criminal defendant, that it occurs at criminal sentencing, that for misdemeanor offenses, it's the only punishment a defendant might receive, that it's the United States that is the adversarial party that can enforce restitution and the obligation to impose restitution in the first instance, and then exercises the primary authority on the back end. And then on top of all that, that restitution is codified within the criminal code.
So if I can paraphrase, Ms. Robertson, your suggestion to us is that we throw in absolutely everything so that in some future case, we will be sure to have some sort of distinction.
I think our test here is consistent with any ordinary principle of statutory construction, which is we don't want to suggest there are hard and fast rules here. And yes, we do
say
think...
yes. You can just say yes.
We do think it's important to rely on all the textual clues.
Well, what about the prior statute? Was that punitive too?
Yes, we do think that restitution under the VWPA was criminal punishment. The government took that position.
Well, then what do you have to say about Section 2 of the VWPA, which says explicitly the purpose of this is to help victims?
The reason that the government took the position when this question was litigated that the VWPA was a criminal punishment is because that statute uses similar language to the one at issue here. It does refer to restitution as a penalty. There was also plenty of statements within the legislative history there that Congress intended
legislative history. In the statute itself, Congress lamented that the criminal justice system had ignored the physical, psychological, and financial hardship of victims, found that the criminal justice system focused only on identifying and punishing offenders. As a consequence, victims had lost valuable property to the criminal. Congress enacted that act with the stated purpose of ensuring that the federal government does all that is possible within limits of available resources to assist victims. If this turns on congressional intent, how much clearer could congressional intent be than that, right in the statute itself?
We would draw a line between whether Congress intends something to be punishment and the purposes that a particular punishment might serve. It's not unusual, for instance, for criminal fines to serve a compensatory purpose. By statute, most criminal fines are obligated to the Crime Victims Fund. So we do think that a punishment can serve a compensatory purpose, but there's still the threshold question of whether Congress intended to implement the measure as a punishment. And for purposes of
this— I thought the question was congressional intent. If Congress says our intent is to assist victims, isn't that open and shut then?
Well, we think the fact that Congress refers to restitution as a penalty is similar to saying restitution is punishment, and there's no plainer statement of intent than that from the text. But for purposes of this case, I think it is important that whatever questions might have existed about the VWPA when it was first enacted, the courts of appeals uniformly treated VWPA as criminal punishment. That's a consensus that this court observed in Kelly. Congress was legislating against that backdrop.
Maybe they were right, maybe they weren't. Maybe they, like possibly you, are worried about the consequences of saying that it's not that it's not penal. But then you have the VWPA followed by the MVRA, the mandatory victims, talks expressly
They're
about
usually
victims.
somewhere on
Doesn't
YouTube.
that show what Congress is getting at?
Or on.
Again, we don't want
sometimes
to
find them on the
gainsay
Supreme
the
Court website.
important role that victims play in Congress's motivation here, but just as to the threshold question, we do think Congress's intent to implement criminal punishment is clear. And as to the consequences, there is a real consequence to treating restitution under the MVRA as a civil penalty, and that's the concerns that it would implicate the Seventh Amendment. We think that was the concern that was top of mind.
Ms. Robertson, I just wanted to ask you analytically, and I'll show my cards and say it's just because of thinking about this DIG argument. Do you think analytically we should be thinking about these as two distinct statutes, or should we be thinking about the VWPA and the MVRA as just different amendments to the same basic statute?
We think that you can think today of both Section 3663 and 3663A as part of the MVRA, because restitution imposed under either scheme would be subject to all of the MVRA's many provisions, including its collection authorities, its procedural safeguards, and all of those provisions are relevant to the court's analysis. But to be direct about the DIG, if the court wants to identify the provision at issue here, we do think it should take the case on the premise that it's Section 3663A. That was the government's position before the Court of Appeals. The Court of Appeals accepted that premise. Petitioners no longer disputing it or asking this court to revisit that factual predicate. And so we think it's appropriate for the court to resolve this case on the same basis that we asked the Eighth Circuit to rule in our favor below.
And that section was not in effect when he committed the crime, correct?
That's correct. So
that's the source of the ex post facto problem. No matter what happened at sentencing, at the time he committed the crime, 3663A was not in effect, and today he's being held to account under that provision.
That's correct, Justice Jackson. I would make one clarification. The MVRA by its terms applied to petitioner. So if the district court didn't apply 3663A, it could have only done so if it determined that that provision was criminal punishment, the very question at issue here. Now, there would be a separate question as to whether the limitations period that the government is currently attempting to apply to petitioner might constitutionally apply. It's our position that it could, even though his restitution obligation was criminal punishment, because we don't think increasing the time to collect restitution increases his punishment.
That's the argument you want to preserve.
But that's the argument we're trying to preserve for remand.
Can I just go back to Justice Alito's colloquy with you? Because I guess I'm still wondering whether your argument flows from the idea that there might be different purposes of punishment, and that you could have a punitive measure that is imposed for rehabilitative circumstances, and with an idea that you are making this person pay back society, you're making this person make amends for what it is that he's done, but it really is still a part of the punishment in the way that theorists have traditionally understood.
We're getting into a whole discussion here about debt to society theory, which is fascinating, but I don't have time to throw it in right now.
Where it said that restitution serves as a particularly effective rehabilitative penalty precisely because it forces the offender to confront in concrete terms the harms that his actions have caused to a real person, more than a fine, which is paid to an abstract entity like the state would. It also serves a particularly effective deterrent purpose for that reason, by closely aligning the punishment that the defendant faces with the harm that he's caused.
So even if it's victim focused, it can still be punitive in this way.
Yes, absolutely. And we do think that this punishment here serves penological goals as well as compensatory ones.
Thank you.
Bless you.
With respect to our opinion, if
Christmas, what do you want me to put in the link
you
tree?
also want us to say something about the Sixth Amendment, or to avoid saying anything problematic about the Sixth Amendment, correct? What do you suggest?
We think that the cleanest way to resolve this case when it comes to constitutional avoidance is to recognize that constitutional avoidance only comes into play where After exhausting all the ordinary tools of construction, the court is left with competing interpretations that are plausible, and one would avoid constitutional concerns. Here, we don't think that there are competing plausible constructions. We think that Congress's intent is unambiguous. We also don't think that there's a construction that would avoid constitutional concerns, because calling restitution a civil penalty
You
would
might
raise
be
Seventh
referring to the
Amendment.
Seventh Amendment. My question was about your footnote about the Sixth Amendment.
Right, so we don't think that the court would only need to address the Sixth Amendment if there were a legitimate claim to be made for constitutional avoidance, and we simply think that there's no legitimate claim here because there are constitutional concerns on either side. Of course, even if the court agrees with us that restitution is criminal punishment, we have alternative arguments for why restitution wouldn't implicate this court's decision in Apprendi, which we would continue to make.
Right.
Christine, this is the government attorney arguing.
Justice Thomas, anything further?
We're arguing over whether restitution payments are part of punishment or whether they're a civil payment.
Even if this were
Punishments
civil,
cannot, under ex post
civil
facto, cannot be
retroactivity is
changed once the crime is completed.
something that we
This guy had
countenance without
his
a clear statement.
restitution payment situation
So
changed
we
later.
think that the court has been clear that the ex post facto clause itself only applies to criminal punishment.
Right, you disagree with Professor Logan on that, yes.
Yes, we do. We do disagree on that point. We take the case.
But we do, Landgraf and other cases, civil retroactivity is something that's antithetical
Christmas, let me
to
see if I've ever
basic
put that
rule of
video
law
on YouTube.
notions, at least without, in many instances, not always, but
Oh,
Landgraf
will you guys
says
tap
that
your
too,
screens, by
right?
the way? And
So
TikTok?
we agree that it would be unusual for Congress to apply either a civil or criminal penalty retroactively, without, of course, a clear statement that it intends to do so. We have that here. Congress clearly intended to apply the MVRA retroactively to the extent constitutionally permissible, and it's important to us that many of the MVRA's provisions can apply retroactively, even though it's criminal punishment, because not all of the MVRA's provisions increase that punishment.
Thank you.
Justice Jackson? Thank you, counsel. Mr. Bash?
Thank you, Mr. Chief Justice, and may it please the court. I'll take the dig argument I make first, and then I'll move on to
this is the guy
merits.
who they brought in
To
to
clarify
argue
the dig
the
argument, and this
far
goes to
end,
questions from
because
Justice
nobody
Thomas,
else
Justice
was.
Jackson, and Justice Barrett. It's not only that at the time of sentencing, the judgment form said the old statute. The position of the Solicitor General at the time, consistent with the proviso in the statute that said only apply this retroactively to the extent you believe constitutionally permissible, was not to apply the statute in cases like this. The district court found in this proceeding that the sentencing court did not apply the statute on which the question was presented in this case. The Court of Appeals did not disrupt that finding, as far as I can see, and I don't think it would matter if it did. But at page 4A of the PEDAP, the Court of Appeals says the MVRA is being applied retroactively in this case, but what it meant by that was the 20-year extension provision. But Justice Jackson, whether that would be an ex post facto problem turns entirely on what it's extending. So if that provision applied to something that, let's say, this court had already determined was a civil penalty, the mere fact that it's contained in the same statute as a restitution obligation that is assertedly criminal would not make the application of the 20-year provision to the civil penalty into criminal punishment. So I do think, Justice Thomas, that the court has to decide what was applied in this case, because the question presented relates only to the second statute, not the first statute. And Justice Barrett, this is in a context in which, as Justice Kavanaugh noted, congressional intent is one of the key considerations, and the intent behind the 82 statute may have been very different than the intent behind the 96 statute. And just to respond to one more point on this, I think I heard the government say that, well, even if it applied the other statute, it's all part of the same statute now. But remember, what the sentencing court likely did, consistent with the Solicitor General's position, was apply the pre-MVRA version of the VWPA. So it's not as if it applied the amended version, which maybe that would present a closer question on the dig. It applied the pre-MVRA version.
Because
I
it's
see my
just
yellow lights.
money,
I'm happy to take the
is it
questions
still
from the court,
part
Mr. Chief
of
Justice.
the punishment or not?
But it's the considerations between the two different statutes would, on a higher level of generality, be about the same, wouldn't they? I mean, there's not that much difference, and we're not dealing with the the increase or in time that it expands at this level. So what difference would it make?
Justice Thomas, I do think there are some pretty critical differences between the statute, the two statutes, although my ultimate position would be that neither are punitive. But one big difference is that, especially under the earlier version of the VWPA, the sentencing court could not only decide whether to enter restitution award, but decide the amount based on ordinary penological considerations, culpability, the defendant's circumstances, whether the defendant has dependents, and so forth. That is prototypical of the criminal justice system, which focuses a lot on the circumstances of the offense and the defendant. The MVRA is totally different. The MVRA is a pure compensation regime that parallels the tort system. It does not care about the defendant's culpability. It does not care if the defendant has dependents. It's full restitution. That is characteristic of the civil tort system. And so I do think there are differences. The legislative history is very different. The MVRA is way more focused on victim compensation than is the legislative history of the VWPA.
Would it have made a difference had there been a separate proceeding that looked more like a civil proceeding than doing this at the sentencing stage?
I think that would make it an easier case, but I don't think the outcome should turn on it. So let me just put it this way. Virtually every feature of this statute, it's full restitution, no less, no more. There's offsets for civil judgments. The victim can continue to petition indefinitely for further compensation, for example, for medical bills that continue to arise in old age based on an assault. It can be enforced through a civil lien. Even when the Attorney General enforces it, he or she enforces it in the manner of a civil judgment. The defendant has to notify the victim when his or her ability to pay changes. All of those are clearly features of a civil compensatory system. Now, I think if that was set up with a different case number, where what happened is the victim or the Attorney General could take advantage of the collateral estoppel effect of the criminal judgment and just do everything exactly the same, but it had a different case number on it, I think there would be no question that the court would consider it a non-punitive remedy. So I think the question before the court is, if Congress chose, for what I think are pretty obvious efficiency reasons, to fold that compensatory remedy into criminal sentencing, does that make it punitive? Here's why I think the answer to that question is no. When this court has in the past looked at the nature of the proceedings to answer this question, and those were invariably cases in which the proceedings were civil, and so the court said the remedy was civil. There was really no other explanation for why Congress chose that form of proceeding than that it intended the remedy to be civil in nature. That's not true here. Here, there's a pre-existing criminal proceeding that will happen no matter if there's restitution or not in order to impose a criminal judgment and imprisonment and so forth. And there's a perfectly plausible and I think likely explanation for why Congress folded this compensatory remedy into this proceeding, which is way more efficient to get victims the compensation they need.
But your argument it just seems to beg the question, right? The question is whether Congress intended this to be a compensatory remedy. We're not sort of asking, well, why did Congress put this compensatory remedy here? We're asking, is this compensatory, meaning civil, or not? And I guess I feel like you're struggling a little bit against the weight of all of the consensus that existed with regard to the VWPA, the pre-existing statute that this statute was amending, everybody thought was criminal. It was all over the legislative history. It was in the statute. No one questioned it. And so I guess I'm asking you, is there some kind of indication that Congress was intending to shift or depart from that well-established understanding when it enacted this statute that was just amending the prior one?
There are substantial indications, Justice Jackson, and here they are. I'd start with the structure of the statute. Under the VWPA, as it existed when those courts of appeals decisions were rendered, the sentencing court could take into account culpability, deterrence, just punishment, the circumstances of the defendant and his or her dependents in deciding not only whether to impose restitution, but in calibrating the amount. In that respect,
so they made it mandatory. You don't get to take those things into account, but why does that mean that it becomes less criminal?
Because that is the prototypical characteristic of the civil tort system. When you sue somebody for injuring you or defrauding you, and the jury says, yes, they did it, and now we need to award damages, The jury cannot take into account, well, I think this person's going to reform themselves. This was their first offense. The jury cannot take into account this defendant has dependents, and we want to calibrate this. None of that's relevant. The characteristic of the civil tort system is the same as the MVRA: full compensation and no more. So that is why there's a huge difference between the MVRA and both the VWPA and the state system that this court considered in Kelly. Can I just offer you a syllogism that I think makes the point especially clear?
Sure.
So, two propositions, both from this court's case law. One, in a lot of cases going back to Helverine versus Mitchell in 38 and Marcus versus Hess in 43, this court has said that when a remedy is compensatory, it is not punitive. And even treble damages provisions, the court said, well, that's a rough form of liquidated damages.
I'm sorry, was this in criminal cases or are these civil cases? I'm not.
These were cases deciding that a remedy was not punitive, I think in the double jeopardy context.
But in the context of a civil action.
These were civil actions, that's true.
Okay.
That's true. That is a distinction here, and I can address that in a second. But this court—
I mean, isn't that relevant? We're in the context of a criminal proceeding, and the court, the sentencing court, is imposing this as part of the punishment.
It's relevant, but as I said to Justice Thomas a few moments ago, I think the nature of the proceedings has been relevant when it gives rise to an unavoidable inference about what Congress intended, but it's very different here, where those proceedings would happen either way, and there's an obvious efficiency route.
What do you do with the legislative history for the MVRA, where Congress says it is needed to ensure that the loss to crime victims is recognized and that they receive the restitution they are due? It is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. That second sentence sounds very rehabilitative to me, which is a purpose of punishment.
And that's exactly the second part of the syllogism I wanted to get to. In 89 Firearms, one of this court's cases in this area, the court said that the inquiry is whether the remedy is more remedial than punitive. In both Paroline, which is one of my opponent's favorite cases, and Dolan, this court said the primary purpose of restitution is remedial. If you put those two things together, if the question is whether it's more remedial than punitive, and this got to a lot of the questions that Justice Alito was asking to my friends on the other side, clearly this compensatory tort-like system is more remedial than punitive. It's designed to get victims compensation. The last thing I'd say about that, Justice Jackson, is this court has repeatedly recognized that virtually any monetary exaction or other sanction, whether civil or not, has a deterrent effect, just like the tort system has a deterrent effect. When you get I'm sorry, Justice Gorsuch.
No, please finish your—
I mean, just like the tort system has a deterrent effect. That's a big purpose of the tort system, is to deter tortfeasors from doing torts. But that doesn't make it punitive. And so if the only deterrent effect that arises from a monetary exaction is the deterrent effect that any form of compensation would have on the relevant behavior, then that's not enough to shift the balance from remedial to punitive. Justice Gorsuch, I'm sorry.
I just wanted to give you an alternative hypothesis about the shift between the VWPA and the MVRA, going from more discretionary amounts to a mandatory amount. Could Congress have thought, yeah, this is punishment for sure, it's punishment for all the reasons your friends on the other side say and all the courts of appeals concluded with respect to the VWPA, but district courts are simply not exercising their discretion appropriately, and we're going to take that discretion away. In much the same way that sometimes Congress takes discretion in sentencing prison terms away and creates mandatory minimums. Thoughts?
Well, I think it's conceivable that Congress could have had that intent, but at least in terms of the legislative history of the MVRA, nothing like that is shown.
How about the MVRA? Isn't it pretty clear that was what was going on?
I think what's in the MVRA?
Yeah, Congress thought that discretion needed to be taken, more discretion had to be taken away.
Oh, no, Justice Gorsuch. I think what Congress looked at was an epidemic of hospitalizations and fraud, wiping out people's life savings, and it being too hard for victims to get the compensation they needed.
Okay, all right. And that the awards were not appropriate, and they needed to be more severe.
But, well, you know, they needed to be more compensatory.
Okay.
And as I said, in cases like Marcus versus Hess and Helverine versus Mitchell, the compensatory nature of a remedy has been the lodestar for rendering it non-punitive.
It could be more compensatory, or it could be more punitive, couldn't it?
Well, again, I go back to this court's precedents. This court has said that compensatory remedies, even treble damages that operate—
I understand that in the civil context, but I am asking you to spot a lot. And I'm asking you to spot that, you know, the circuits were not completely crazy in thinking that the VWPA was punitive. And if that's true, then And maybe that's really the source of our disagreement, or at least in this colloquy.
I understand the intuition, Justice Gorsuch, that, well, when you make something mandatory, doesn't that make it more severe
I guess
and so more
thank
punitive?
you, Mr. Bash.
But
you stated my question better than I did.
But I don't think that ultimately holds up, because it is the tort system that is a mandatory compensation regime. It is the civil
Let me know if this
justice
helps
system
at
that is
all.
a mandatory compensation
There's
regime.
compensatory in both cases before, just an insufficient one, and Congress made it more
People need to
punitive,
read it. I know
more
my handwriting's terrible.
compensatory.
It really wasn't. It was capped at compensation, but it empowered judges to say, how do I impose an appropriate punishment on this person by calibrating the amount of restitution in connection with all the other things I'm going to impose at sentencing. So it was really more of a criminal system.
I understand your point.
As I understand your argument, Mr. Bash, you're saying, well, look, this is compensatory. Here are all the ways we can see that it's compensatory. But I think the opposite argument is
Does that make any
that
sense,
just
Maria?
doesn't get you home, because a compensatory system can have punitive, like, it can be part of a punishment scheme. And indeed, there's a theory behind this, right?
I
Which
know my
is
handwriting
you're
is awful,
forcing
and
the
it's-
defendant to confront the nature and the extent of the harm that he's committed, and that is a powerful way of driving home his wrongdoing. So, you know,
Point
to say
is,
it's compensation, it's like, okay, it's compensation, but compensation
first.
can be a form of punishment.
Well,
And it's replaced by
Justice Kagan, I don't
MVRA
think we need the rule as broad
after
as all
he's
forms of
convicted.
compensation are not punishment. I think that would be open to the court.
That
and consistent
changes
with
it
its
from
precedents,
20
but I don't
years
think
from
you
the
need to
day
do
he's
that.
convicted
I think you can distinguish
to 20
the
years
WPA and the statutes,
from the day
statutes
he's
like the one at
released
issue in
that
Kelly
he gets
that
to stop
say in
paying
imposing
these
a compensatory
restitution
remedy,
payments.
don't just look at victim loss. Look at what's best for this defendant, what's going to
VWPA
promote the purposes
is
of
the
criminal punishment
old one,
and deterrence and so forth.
MVRA is
But
the
when
new
you
one.
have a regime that's essentially just a mechanical compensatory
saying that
regime,
right?
I
I
think
hope.
under this court's precedents like Marcus and Helvering versus Mitchell, that's non-punitive. And I go
I
back
guess
to...
I'm wondering why. If the whole idea of the theory is that it's punishment when you force the defendant to confront the extent of his wrongdoing, what better way to do that than to make the restitution scheme entirely focus on the defendant's loss?
Well, Justice Kagan, let me try it this way. I mean, 3664L allows victims to take advantage of the collateral estoppel effect of the criminal judgment in bringing a separate civil suit. So you can imagine a system where the victim, it works exactly the same way as it does here. But the victim just goes under a different case number, maybe even the Attorney General initiates it or maybe not, and just invokes the collateral estoppel effect of the judgment, and everything's the same. It's a compensatory remedy, it's offset by civil judgments, all the same features here that are laser focused on compensation. I think it would be pretty clear that that's a typical civil compensatory statute. And so the question is, does the fact that Congress arguably, and I think it's only arguably, made this part of the sentence or part of sentencing proceedings change things? And I think the government has to admit that that can't be the line, because a lot of civil things are imposed at sentencing through conditions of supervised release. This court hasn't decided that question before, but lower courts have almost uniformly said that DNA testing, these are ex post facto challenges, drug testing, consent to certain forms of searches, those are all civil things imposed at sentencing because they serve non-punitive goals. In those cases, it's preventing reoffense or reintegration into society. In this case, it's compensating for harm in a way that I think is materially indistinguishable from what the tort system could provide.
Except in the tort system, if the victims receive insurance or some other form of compensation, then you wouldn't have the ability to get the complete relief in the context of the proceeding. And I'm not aware here of restitution being offset by other forms of relief received.
It is, Justice Jackson.
It is?
Yes, under 3664, there's two ways it happens. One, once there's a restitution award and the victim gets a civil judgment for the same harm, it's got to be reduced. So that's civil
judgment.
Right.
But
so
insurance.
Insurance, it's not taken into account in the computation of the award, but then the judge can order that portion of the restitution award go to the insurance company or the other source that either paid it or has a obligation to pay. And the only limit on that is they got to get paid last after all the victims get paid. But it actually is offset.
I mean, I think the argument against you would go back to the way that Ms. Robertson answered Justice Kavanaugh's question, where when Justice Kavanaugh said, "What do you want?" and Ms. Robertson, listed about 42 different ways in which Congress said that this was criminal punishment. And then you're here to say, yes, but look at this intense focus on the victim's loss. And in the context of those 42 different ways, you're asking us to say, well, the fact that they focused on the victim's loss takes us out of the criminal punishment box. And I guess what I'm suggesting is that no, in that context, it's fully consistent with the rest of everything that they did. It's like, yes, it's focused on the victim's loss, but that doesn't make it any less criminal punishment.
I hate to attack the premise of the question, but I don't think there are 42 different ways. Most
really
of the things
hate
that my
to
colleague
do
said
that?
I don't think are persuasive at all. So the thing I kept hearing was that they denoted it a penalty. But this court said in 89 firearms that penalties can be either civil or criminal. We've given a ton of examples throughout the US Code where penalty is used in the civil sense or the criminal sense. Sanction is the same way. And in fact, in one of the provisions my friend relies on, the government relies on, 3551, Congress said the sentence is the fine, the imprisonment, and the probation, and the sanction is forfeiture and restitution. Now, there are other provisions they can point to that suggest it's a sentence. I think in reality, Congress was of two minds on this at different points and probably never formed a judgment about whether it is, in theory, part of the sentence. But even if I accepted that it was part of the sentence, I think that just goes back to the point I made before, which is, can Congress fold a clearly remedial compensatory remedy into a sentence for efficiency's sake without either triggering step one of Mendoza-Martinez by signaling an intent that it be punishment, or making it have to be punishment at step two, which the government doesn't even argue. So I don't think there are 42 different ways. I think this is overwhelmingly compensatory on almost every metric. And sorry, Justice Alito, I'd look at you, might ask a question.
No, I was going to ask something different, but I'll go ahead since there's silence. The government wants to sail between the Scylla of the Sixth Amendment and the Charybdis of the Seventh Amendment. And it seems to think that it can escape the Seventh Amendment by listing 42 things that would be inapplicable in any other situation. But either of those would destroy this regime, probably. So why should, which one is more dangerous?
The Sixth Amendment is by far more dangerous. Let me give you a quick pitch on the dig, though, for that, which is that this is the lurking issue that actually really matters here, and the parties have barely briefed it. The actual question presented is vanishingly unimportant for people who were committed the crime before April 1996, were convicted after. For some reason, the court applied the MVRA, even though the government was saying to apply the VWPA, and they still have an outstanding award. So the actual QP is not very important. As you say, though, the jury trial question could destroy the whole regime. So under the Sixth Amendment, the Apprendi rule, as elaborated on in Southern Union, says any fact necessary to increase the maximum monetary award. I'm going to sub in monetary award, but the court has applied that to fines, requires a jury trial. Lower courts have said in this context that, well, the conviction authorizes the maximum unlimited amount of restitution. As Justice Gorsuch pointed out in a separate opinion in Hester, I mean, that just does not follow logically. Under 3664E, the court
Thank you, Mr. Bash.
He likes hearing his name called out.
Under 3664E, the court has to find by a preponderance of the evidence that particular items of loss have been proved. Clearly, that's fact-finding. For any non-zero amount of restitution, the Apprendi rule would obviously require a jury trial. Of course, the court could always draw exceptions to it. Justice Alito, in the same case, you suggested maybe just kind of drawing a line there, but the Apprendi rule clearly applies under the Sixth Amendment. The Seventh Amendment is much closer to me. So on the original understanding of the Seventh Amendment and its plain text, it says suits at common law. So I think pretty clearly this is not a suit at common law. It's a statutory restitution proceeding. Of course, this
court has said, Mr. Bash, as you are well aware, maybe about to say, and
I'm not going to stop there,
apologize.
Justice Gorsuch. I got more riffs on that.
I'm sure you do. I know. But the court has said, labels don't matter. And if it's in substance a civil trial for restitution, that would have been a suit at common law. Surely, wouldn't you agree?
So what this court has said is that statutory causes of action that mimic common law causes of action, both in substance and in remedy, meaning the Beacon Theater's damages, equitable distinction, trigger the Seventh Amendment right. So let's just accept that the court would not reconsider that. This is not quite a statutory cause of action. It is sort of an unusual proceeding, although the one that had a history behind it at common law, as I think your opinion pointed out. But here's what I think is the important point. This court has been much more context dependent on whether the remedy phase of a civil trial requires a jury finding. So the two cases are Tull versus United States and Feltner versus Columbia Pictures. In Tull, the court said, I mean, this was in a footnote, but the majority said, we see nothing in the Seventh Amendment that requires a jury trial for the remedy phase. And that was a civil penalty where it was very discretionary. In Feltner, 9 years later, copyright damages, the court said that requires a jury trial, but part of that was based on the unique history of the Copyright Act. So all I'm saying is I think there would be historical work to do under the Seventh Amendment. The Sixth Amendment, unless this court really drew a kind of outlier exception to Apprendi, you know, I think the Sixth Amendment case is pretty open and shut under Southern Union.
Isn't that interesting that here you're making an argument that the government has miscalculated its own interest in choosing to take the risk with the Sixth rather than the Seventh?
It does that sometimes. You know, and frankly, I think that
the government's made its bed. Why should we let them lie in it, Mr. Bash?
Well, there is a path-dependent reason, I think, for that, which is that the government developed this position pre-Apprendi. And so it developed this position that restitution is criminal. I'm reading between the lines.
It made the opposite argument in the Eighth Circuit, and here we are. It's flipped its view.
Yeah, I think maybe the U.S. Attorney's Office there didn't follow the DOJ position overall.
And it's admirable that the DOJ flipped its view, I want to say. I think it is admirable that they reconsidered their position, but they've made their judgment.
And all I'm saying with respect to their analysis of the jury trial right is that they developed that position pre-Apprendi, I think, precisely in order to avoid the Seventh Amendment problem. The problem now is, I think, arguably the bigger constitutional problem is the Sixth Amendment. And, you know, I didn't hear, in response to Justice Kavanaugh's question, a very satisfactory explanation of what the court would say in this opinion to avoid the Sixth Amendment problem.
Thank you.
But that's unavoidable. Go ahead. I'm sorry. That's unavoidable. In the civil context, at least at common law, I believe that restitution was not an equity, was it? Claim, or was it a common law jury claim?
So, Justice Sotomayor, this depends a little bit on shifting meanings of the word restitution, and I agree with petitioner who points this out in her brief, or his brief, counsel's brief. Restitution is a word for an equitable remedy that I think would fall on the Beacon Theater's bench trial side of the line when you're talking about restoring something taken. And some of the remedies under restitution take that form. So if someone steals your car,
those of you who don't know, equity and law were at one point two totally different courts.
Line of you don't need a
and
jury
we still
trial.
apply different sets of law to
paying
them.
a monetary
Or
Some
different
of
sets
the
of
forms
rules
of
to them, I
restitution,
guess.
the majority in the statute here, are really traditional damages.
So
forms.
really, jury trials would have been required in the common law. If we required them in the criminal context because it's a substitution for civil, wouldn't be the end of the world, Counselor. It would just be avoiding taking away a right to a jury trial.
I don't think it would be end of the world as a practical matter. It would mean the entire statutory scheme has been unconstitutional for decades because they haven't been provided jury trials. I don't think practically it couldn't be implemented. But as I said, I think the Sixth Amendment problem is much clearer.
This would be a new rule because we pretty much have established precedent to the contrary. Thank you.
I do think there would be an argument under the Seventh Amendment that this could survive under the reasoning of.
So you're not buying their footnote 3 in the government's brief then on the Sixth Amendment? Where they...
You know, the government, I think, if I'm remembering the footnote, rehashed the Court of Appeals views.
Correct.
The judgment of conviction authorizes unlimited restitution. That is just not true. There has to be a finding of particular items of loss. That is a factual finding that you can't, that without which no restitution is authorized. So it's just not correct. I don't see how that, a lot of Court of Appeals have adopted that view, but I don't think it is correct.
And yeah, Brooke, that's why I keep making jokes about this being like, you know, SCOTUS season.
I can't help myself.
This is my
You'd agree that
fantasy
in the civil
league.
context and Seventh Amendment, when you're seeking damages, you usually get a jury trial.
You know, that has been, the court so held in the copyright context in Feltner. I don't know the court has.
And here, nobody's
county
asking
courts,
for the return of
we
the
get into
horse.
state
They're
courts,
seeking damages, right, effectively. That's your view. There's full compensation.
Yeah, I don't think there's a distinction between many of the heads
we talk about
of loss
equity
here and legal damages. I think that's true.
Okay.
The only point I was making is that under Tull and Feltner, I think there's a more nuanced analysis on whether the remedy phase of a civil jury trial, that phase of it requires a jury, because it held for civil penalties at least that it did not.
Gotcha.
That's different than damages, I know.
Gotcha. Thank you.
Wes, I can tell you Barrett has barely been out today. So if you had Barrett on your fantasy bench.
Thank you, counsel. Ms. Zaharia?
Just very briefly, I'd like to respond to Justice Alito's question about the findings and purposes of the VWPA that he posed to the government. If you look at Section 2 of the VWPA, it is replete with references to the criminal justice system and the criminal justice process. Congress was intending to give victims more of a role in the criminal justice system, but there's nothing in those findings or purposes that suggests that Congress thought it was creating a civil proceeding, which is a relevant question here. Second, with respect to the Sixth Amendment and Seventh Amendment question, I'll just say the following. First, I think under the Seventh Amendment, this case is much more like Feltner than Tull because it involves compensatory damages. And what's more, the inquiries that judges make at sentencing really go to core liability type questions of proximate causation. To determine who is a victim, the court has to determine who suffered losses proximately caused by the offense conduct. Those are the kinds of questions that in the civil context, juries always decide. And if the court's gonna pick which one is worse, well, a ruling that restitution is civil would completely upset the apple cart on the Seventh Amendment because the circuits rejected that argument uniformly on the ground that restitution is criminal punishment. In the Sixth Amendment context, the courts, again, have uniformly rejected the Apprendi argument, but they've done so on two different grounds. Only a minority of courts have adopted the civil remedy ground, and all of the courts have said that it's an indeterminate range that just isn't subject to Apprendi. That may or may not be correct, but that would be an issue for the court to address in some future case if it so chose. And then finally, on the point about restitution being mandatory under the MVRA, I would adopt Justice Gorsuch's response to that, which I thought was quite, was correct, that Congress simply made the relevant judgment for sentencing courts and making restitution mandatory. And I think that the argument that restitution is civil because it's mandatory doesn't account for the way that Congress intertwined restitution with all of the other punishments imposed at sentencing. So for all those reasons, we ask the court to vacate and remand.
Thank you, counsel. Mr. Bash, this court appointed you to brief and argue this case as an amicus curiae in support of the judgment below. You have ably discharged that responsibility, for which we are grateful. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
All right. So let me fill you guys in just a couple of things that I think are important. I'm just going to pause, stop that. There's a ton of stuff going on, but I will tell you a few things that actually sort of surprised me here. And I want to flip back, make sure I don't lose anything here. Okay, so what was this one about? So basically, we started with one case. We ended up with Ellinburg. Ellinburg, the question was whether a change in the law that allowed restitution payments to victims by a criminal they were always 20 years. You had to pay them for 20 years. And it started out for this particular criminal who was convicted in 1995, the law said when this person was convicted that you have to pay them for 20 years from the day of your judgment. But like a year later, they changed the law to 20 years from your release. And when he was released from jail, which was actually almost like 28 years later, 25 years later, long time later, he thought, I've already finished that 20 years. I don't have to pay these anymore. And the government came after him and said, no, your 20 years starts today. You got to start now paying all that back. I mean, you've already paid some of it, but you still got to pay that until, for 20 more years. And the question was whether that change that shift is considered a change in punishment, which is not allowed under ex post facto in the U.S. Constitution. So that's basically the overview of the law. And I realized at some point, but it was a little bit too late, that the use of MVRA and the other one were very confusing, which is why I gave you guys that something, even though it wasn't great. The VWPA versus the MVRA, they were a little hard to keep track of, so sorry about that. But there are a couple of things that I did want to point out. First of all, they went in a direction that I probably should have expected. I sort of got it, but wasn't totally expecting it, which was about the rights of a person to be tried by a jury. Because under the 6th and 7th Amendment, there are rights to a jury trial. Some in a criminal situation, some in a civil situation. And they are slightly different. They have different laws attached to them. They have years of case law attached to them. And they are different. But when you go through a criminal case versus a civil case, you do it in a different way, and your jury situation is going to be a little bit different. So the question was, if this is being applied to you as a criminal, is it going to be different enough that this needs to be treated as a punishment under the 6th Amendment, as opposed to going through a civil jury under the 7th Amendment? So that was a whole kind of backwards-facing argument that I had not really gotten into yet, so that was interesting. Other discussion that came up pretty strongly that was brought by that third guy, which was pretty impressive, I thought, was that when, and he kind of turned the argument that I had on my head, which was, I was thinking, if a judge or whoever's doling out this punishment is going to sit there and say, okay, so I need to come up with a punishment for you, whether it's the judge, whether it's the jury, whoever it is, and they think, okay, we're going to put you in jail for 10 years. And we're also going to make you pay your victim $10,000. And it's like, well, since we're making you pay your victim $10,000, I think maybe we'll pull that 10 years back to like 9 years and 9 months. Because that, it seems like since we're adding the money thing, we'll pull that back a little bit. And I thought that sort of made the argument a little bit stronger that it was part of the punishment. Because you were considering all of these things together, it was part of the punishment. I think the argument that they were making is that because it was considered as part of the punishment, and because it would actually reduce potentially the punishment, that Congress considered that when they wrote it, and it made a stronger argument that they intended, if any language they had in there that may have pushed it over as a civil penalty may have been intentional. So why hasn't anyone argued for the... Can you, when you say the party civil system, are you talking about... You have to excuse me, Skate, I saw that before, but the problem is that I came from a code civil system, and so party civil system, code civil system. Can you give that question to me in context a little bit? And so anyway, the idea is that that they had maybe considered that as they were building this, and when they made this, because they said, they made this mandatory, and so therefore it has to be part of the punishment. And the counter argument was, well, of course, but they knew what they were doing, and they understood what this meant, and they knew that this might actually pull back some of the punishment. So they had considered that already. Which, I don't know, but it did make a slightly stronger argument than what I was expecting going in. I was really expecting it to be a little bit weaker, particularly because nobody, like, my understanding is that nobody really wanted to defend the argument, and so that's why they had to bring that third person in to argue, was because there was nobody there. So the court brought this, that third person in to argue the point, because nobody else was doing it. None of the parties were doing it. So it's an interesting point, one way or another, and we should hear it soon. I want to hear what Skate, if you can give me just a little bit better post-game thoughts on how this will go. It's a little bit tighter than I thought it would go, but I still think they're going to end up finding that this is... Yeah, the devil's advocate is exactly what it was. I still feel like this is going to end up going the same way I thought, but I'm maybe a little bit less certain than I was walking into this. I thought that what they were trying to do was wrap up a circuit split, but that they already kind of knew how they were going to end. And keep in mind, guys, so this particular situation was pretty narrow. This isn't going to happen a lot. This particular situation where someone was convicted in 1995, just before that law changed over, and is now challenging it, almost 30 years later, is not going to happen very frequently. The bigger question is whether restitution is a criminal law that is subject to ex post facto in case the government decides to make another change to the restitution laws at some point. That's a bigger question. Not so much this kind of narrow question about this particular law. But at the end, what they could end up doing, and they do this all the time, is they could end up saying, yeah, in this case, we're going to flip it or whatever, but only in this case, only as relates to this particular law, and here's why it only applies here, which they do have a tendency to like doing. They like to keep their decisions narrow when they don't feel like making more often than not, they do tend to do that. What if lack of payment causes increased burden to victims due to inflation and interest? Well, so the thing is that as a general rule, from a mile away, from up a bird's eye view, the theory of all of this is that you have a civil system where an injured person comes to the court to get repaid for their injury. That is what the civil system is supposed to be designed for. That's supposed to be where you get paid back for the harm that you endured. Or, if you got hit by a car, that's where you go to get repaid for any hospital bills, that kind of thing. That is where you go in the civil system. And if you are a victim of a crime, that's where you go to get repaid for any damage that came from that crime. But that puts you in the driver's seat. And there is part of this argument is that the victim being in the driver's seat gives them, it puts a lot of onus on them. It makes them do a lot of stuff, which in some ways is kind of unfair. But on the other hand, it also allows them to make decisions that they couldn't do any other way. So, for example, one of the things that I saw in the briefs is that they can decide to take a settlement if they want. If they're like, okay, I've hit a point where, I know I asked for $100,000, 50 will get me where I need to be. I'd rather take that and walk. If it's not in their hands anymore, this situation, they put this guy, they told this guy to pay his victim $7,000. It's been 20 something years and he has so far paid him 1/4 of that. So he has paid him over 20 something years, $2,000 or something. 20 something years ago, he might have been able to get $3,000 out of the guy immediately and walked away. Might have been in much better shape. So that's why we have a civil system and a criminal system, and they're separate. This was an addition that was supposed to add to that. This is, in general, the idea of, hey, Larry, how's it going? In general, the idea is that in the criminal system, all right, there's like 10 different theories of criminal law, and I don't want to get lost in them, but one of the theories, and one that is not uncommon, is, one of the main theories that you learn kind of at the beginning of criminal law class is the debt to society theory, which is that, if I need to make $100 to buy food, I'm going to have to spend X number of days working to make that $100 so that I can buy food or whatever. If somebody else, rather than spending, let's say it's 7 days, rather than spending that 7 days working to get that $100, if the person next to me decides to just steal the $100 from me and leapfrog that 7 days, he has not only stolen $100 from me, he has stolen a week from the rest of society. He has not put in that week that everybody else had to put in to get from point A to point B. And so he owes everybody else in society a week. And so it's this theory, this debt to society, is that you are now repaying the leapfrog that you took, the shortcut that you took to get to where you needed to go without working for it. That is your debt that you owe. And so we put you in jail to repay your debt to society. And it's, the violation of the social contract. It's a lot of different things, but that's one very kind of physical way of thinking of it, is that you're repaying this debt. I like to visualize it in terms of days and money, because it makes it just a little bit more, a little bit more tactile. But I think it's a good way to kind of visualize this idea of the debt to society. But one way or another, you have skipped over something and gotten something that other people did, would have had to work for. And so you've stolen from society. You owe society back, and so now you're going to repay that. And it doesn't, frankly, it's not a great theory. It's not a great theory. It's a theory that doesn't really work, but it is one of the main underlying theories for our kind of whole system of criminal justice. And so it appears in a lot of different ways. And that's what, I brought it up a little bit, earlier, because we were somehow it came up, as we were talking in there, and I was like, oh, there's a debt to society question here, and I wanted to explain it, but it was going to take too long. So let me see here why I was explaining that to begin with, because now I can't remember. So lack of payment. Oh, so this is the idea, is that you got the civil case where the victim gets repaid for the money that they actually lost. I had to go to the hospital and that cost me money. My car, whatever. The actual victim, the actual costs, I'm going to go to civil court and I'm going to sue you to get my money back. And meanwhile, society is going to sue you to get its whatever back. And the criminal case is part of society taking its thing back. So both of them are the victim and society each going after you for the different things that you took away. This whole concept is that people felt that Congress was not putting enough consideration, hey, Penelope, how's it going, they weren't thinking enough about how this was affecting the victims, that they were putting too much concern into some other stuff instead of that. And that's one of the things that they talked about a little bit in there. And so Congress decided to make this new law and make this these mandatory payments back to the victims as part of the punishment. But this is the question. At that point, does it become part of the civil case or not? When you're paying somebody back for their damage, does it become a civil penalty at that point? And so that's what this whole question is sort of about. And all of this does presuppose that SCOTUS got the ex post facto question right in the first case. So this is, a really big question that's going to have to go. But I was trying to give you, that's sort of, there's a lot of background kind of behind all of this that you got to got to just have in the back of your head. Yeah, it does seem more punitive than rational. There are a lot of reasons. I remember at the beginning of Crim, you start out by learning several, I can't remember how many, different like theories of law and punishment. And one of the things that you learn, which is a little bit upsetting, is that none of them actually work. Most of them make us feel better and don't, like, the problem is, as we've gotten better at tracking things numerically, we discover that they don't work super well. Like, none of them work super well. They may have little bit, they may help a little bit here and there, but none of them are great. And we have all sorts of different parts of our law based on these things that are a little bit not amazing. So every lawyer has been through reading that stuff, and I think a lot of us just sort of pretend it's not there because we don't know what else to do. I'm not sure. I think that might be a slightly, that's probably a slightly glib reading of it, but it's, Oh, thanks, Zooline. But anyway, inside the criminal. Oh, okay. But it is kind of one of the things you go through during law school is learning these. During criminal law, you learn some of these things, and it's interesting. But some of them are more practical. Some of them are more punitive. Some of them are more this or that, theoretical, philosophical, and really. But what's really interesting is as you go through different laws, you can see, and different forms of punishment, you'll see, oh, this is coming from that, this is coming from that, this is coming from that. You start to recognize where they're coming from. Anyway, all right. So I am going to wrap up. I wanted to get you guys all the way through this, and I wanted to try this and see if it worked, and it kind of does, which is great. We were able to actually listen to the case, so I'm very excited about that. And I'm sort of able to see the comments, which is even better. But I'm gonna try, if I can get my morning report out early enough in the morning, I will do this again tomorrow. Tomorrow's going to be a big one. Tomorrow is Calais v. Louisiana. So I have got a lot of reading still to do on that case. So be prepared for that. That's a really huge case. So anyway, but thank you all very, very much. And I appreciate everybody stopping by. And I will see you all probably tomorrow, if not before. Actual work tomorrow. Sorry, Brooke.